heard everything from Sergeant LaCroix, and it is the defense position, Judge, that as to both search warrants, I think our main argument, and that we will, incorporate our written motion, all the arguments made there. At this point, I think the main argument that we would make is that the affidavits for both warrants lack probable cause for the issuance. There was not enough to actually tie Mr. Baker to anything aside from just a mere presence on the scene. I find it disconcerting that the only piece of evidence that could have possibly implicated Mr. Baker as more than just mere presence was completely left out of the written affidavit. And even though Detective LaCroix says he provided clarifying information, I remain unconvinced that at this point, nearly 5 years later, that Detective LaCroix is able to recall specifically what he told the magistrate without any written record of what he told the magistrate. So I would submit to the court that the better record of what was actually told to the magistrate judge, and this applies, of course, to both search warrants, but that the better gauge of what was actually told to the magistrate court judges is what's contained in the affidavit. And again, both of these affidavits do not list out that claim by Mr. Koski that he took a gun from Mr. Baker. And in fact, as Your Honor pointed out in your clarifying questions to Sergeant LaCroix, was that affidavit for the search warrant for Mr. Baker's home made it clear that the statement from Mr. Koski was that Mr. Koski brought both of the weapons into the home himself, that he had stolen the weapons earlier in the day, not Mr. Baker, and that when he entered the home to commit these murders, that he brought those weapons in, not Mr. Baker. Everything in the affidavit, all that it points to regarding Mr. Baker is just a mere presence at the scene. Not involvement, not that he pulled the trigger, not that he killed anybody, not that he actively participated in a murder, not that he aided, not that he abetted in any of this, that he was in the home and did not have a weapon. So, on top of that, Judge, as the search warrant for Mr. Baker's home, Mr. Koski told the police where two weapons were. They actually recovered one of them at the specific location where Mr. Koski was. To then turn around and say that we also need to search Mr. Baker's home for that weapon, for that other weapon that was unrecovered, even though Mr. Koski told them where it was, is disingenuous at best, Your Honor. We again, Judge, it is our contention that there is not enough probable cause that for the DNA, not enough probable cause to tie Mr. Baker to anything that would require getting his DNA. I think all that evidence shows that he may have stepped foot in the house and then left. That's not enough to say that's his DNA possibly on a beer bottle just from stepping in the house. We don't believe that there was any cause, any need to give Mr. Baker's DNA, not enough probable cause to show that there would be any evidence of the crime of murder contained in Mr. Baker's DNA. And again, same thing with Mr. Baker's home. They're contained in the affidavits, and for whatever weight the court wishes to give to the testimony of Sergeant McCoy, that there is not enough information to rise to the level of probable cause that evidence of any of these crimes would have been contained inside Mr. Baker's home. And for all of those reasons, we would ask this court to grant our motion to suppress and to suppress, as I guess what would actually be suppressed as it relates to the search of Mr. Baker's home would be every single photograph that was taken of his home. We would ask that those be suppressed. And as to the second search warrant, we would ask that the DNA be suppressed.
I was wondering what you were going to ask me to suppress other than the DNA evidence. The return is 0.
Well, yeah, and that's the thing. I mean, there was no physical evidence taken, but from Mr. Baker's home, to be clear, there was nothing physically removed. But they entered the home pursuant to a search warrant.
Right.
absent the search warrant, would not have been able to take any photographs inside Mr. Baker's home. And so even though there was not a physical item that was taken and removed, it's our position that any photograph falls within the purview of that search warrant. The state of the home, any photograph taken was evidence seized pursuant to the search warrant.
I don't think I've ever had an opportunity to rule on this motion, search warrant, motion to dismiss the search where there was nothing inventory to suppress.
And
The photographs are not listed on the attached here, the inventory consisting of 0 pages of the instrument, article, or things which were seized pursuant to the search warrant. Nothing in here indicates they were searching or obtaining photographs, which I would say this either admissible or not admissible, not because of the search warrant. That would even be admissible to prove anything. But I just want to make sure I was clear. I've never had one of this nature.
And neither have I, Judge, and I think maybe that's why there's not extensive case law on that.
Well, I would suspect so. They probably didn't.
Typically
let me
something
ask this question while we're here and you're finishing your argument. As to the DNA, has there ever been any match with any other evidence? I mean, they took swabs from bottles and all that. I mean, it should have been provided to the defense if there was.
I would leave that question to the state, Your Honor.
Okay, y'all should have been provided with anything. Y'all opted in, didn't you? Discovery?
I'm sorry?
Didn't y'all opt in to discovery?
We did that?
Yeah, so I mean, if they've got DNA matching up Mr. Baker with something in the residence when the 4 people were shot, I suspect you know about it by now. But I'll find out in closing on the other side, maybe. So, again, I'm not sure how that is a negative for Mr. Baker. That's one of those things, if you get to the trial, if in fact we have a trial, I'm not saying there shouldn't be, if you do, I would want to know, got no DNA. They took swabs of him, and they got nothing matched up. They went through his house, found absolutely nothing that they were looking for. That's a positive on the jury. We're looking at, did you look in the house? Yeah. Did you find anything? No. But anyway, let me hear from the state.
Your Honor, I had the same questions because I asked, what are we suppressing? Because there was nothing taken in the search warrant of his home, and to my knowledge, the DNA didn't match. And so, to my knowledge, and as far as I'm assuming the defense knows, there's no DNA match here.
This is where I get to be the lawyer on the other side. However, we just found out today that we have a video. Now, who's to say that somewhere down the road before we get to the trial, if something doesn't turn up, we all don't know about it.
That's correct, Your Honor.
And if in fact it's suppressed, DNA is swab, and that is the DNA that could not be used. There we go. I think that may be what I would argue. The search warrant, the other search warrant, I'm not sure if nothing was taken and there's nothing to show up. So that, would you like to finish? I'm sorry.
I would. Thank you, Judge. I appreciate it. So I did want you to know that when we came into this, I wasn't sure what we were trying to suppress or what the defense was trying to suppress because neither search panned out for the officers. That being said, I wasn't willing to concede. Not gonna concede that it's not a valid search because I think that it is important for the state to be able to present at trial that they tried. That they certainly tried to do these things because we all know that in trial, oftentimes defense attorneys say, they didn't even try to get DNA. They didn't even try to get fingerprints. They didn't even try to search his house. All these things. I think it's important that a jury understands the steps that were taken. So just so Your Honor is aware, I'm not looking to waste your time, but these are important things that may come into play in front of the jury, letting them know the steps that law enforcement took, that they did try to do a thorough investigation to see if they could find these items. Particularly since in his interview, the defendant said he was wearing the black hoodie. So one would assume that the black hoodie clothing that he was wearing is going to be at the house. It was not. That being said, with regards to there being probable cause to search his home, what the magistrate judge knew was that he was in the house during the murders. He met up there with Mr. Koski. He went through the house with Mr. Koski. That another witness saw Koski and another male walking down the hall, appearing to be working in tandem, searching for people. On top of that, we have Mr. Koski, who told officers that after he shot the four young adults in the home, that he then had Mr. Baker walk through the home because he knew that there was another guy in the house. So he knew that this other witness was there, just couldn't find him. So we have not just Mr. Koski's word on that, but we have this independent witness who said that there was a guy walking down the hall with Koski appearing to look for other victims. And then we have in Mr. Baker's interview, he confirms that he was the guy walking down the hall with Jacob Koski. Now, he says that's not what he was doing, certainly, but it's not a great mystery at that point who was with Mr. Koski. By his own admission in his statement, he was telling the officer that yes, he was with Koski. So those are things that the magistrate judge knew. We also know that Mr. Koski indicated that he used 2 firearms. They found one firearm. What the defense wants Your Honor to believe is that because Jacob Koski led them to one firearm, the fact that they didn't find the other firearm, they were supposed to be like, okay, well, I guess we're never going to find that thing. What we know is that Jacob Koski said he threw firearms out the window. They couldn't find the one. We have witnesses in the car who don't recall Jacob Koski throwing anything out the window. Jacob Koski led them to one firearm that was down near where they dropped him off, down near, I believe it's exit 212. So he led them to the one firearm, but they could not find the other firearm. It's not unreasonable in any way, shape, or form to believe that that firearm, along with that black hoodie sweatshirt, could be in Matthew Baker's home. They were in the house together. They left together. He never called the police. He never did anything to report it. And so it is not unreasonable to believe that those items could be found in his home. We know based on his interview that they were at the house, his home, supposedly once they got back to there after coming back from Moccasin Gap, that they were at his home all night. So it is not unreasonable to believe that those items could be in there, could be in the home. And that's what we're looking at when we're looking at probable cause. I know Your Honor knows this, but I gotta put it on the record. The affidavit in this case is facially sufficient and is not overbroad. It tells what items they're looking for, where they're looking. It gives enough probable cause to establish why they need the search warrant. And then we also have information from Detective LaCroix that he supplied additional information to the magistrate judge. And I noticed that the defense likes to throw around this word disingenuous all the time, as if folks are lying. We have an officer who swore under oath answering the defense's questions with regards to what information did you give the judge. And he didn't come up with 15 different outrageous things. He specifically asked him questions and he told him, I don't remember the specifics, but I do remember he was asking me about contradictory information. And so I told him people's testimony, people's interviews, things that they said that contradicted each other. What were some of those things? And he gave those. So I don't think there's in any way, shape, or form him being disingenuous. He was answering the defense questions and he answered them in the same manner, meaning that when the judge asked him what was some contradictory stuff that you had, that is the information that he gave him. That's not lying. That's not disingenuous. Disingenuous is just a nice way of calling somebody a liar. That's not lying. He came out and told him, these are the specifics about what I told him. With regards to a search warrant, Your Honor, and I have a copy of the case for the court if you would like one. We're talking about a search warrant. The issuance of a search warrant, and I'm referring to Jackson v. State. It's 306 Georgia 706. It is a 2019 Supreme Court of Georgia case. They talk about, and Your Honor, would you like a copy? May I approach? I brought a copy for defense. Get a copy to the defense counsel. Thank you. Your Honor, in Jackson on page 10, I believe it is, at the very bottom, they talk about that Jackson argues that trial counsel is ineffective for failing to file a motion to suppress, and because the search warrant application did not establish probable cause to authorize the issuance of the search warrant. they talk about what is necessary. In that second column on page 10, they talk about that, here we go, in making the practical common sense decision of whether a probability exists that evidence of a crime will be found in a particular place, the magistrate must consider the totality of the circumstances set forth in the affidavit, including a consideration of the veracity or reliability and the basis of knowledge of witnesses supplying hearsay information. Goes on to say the probable cause test requires only a fair probability, quote, less than a certainty, but more than a mere suspicion or a possibility, which by no means is to be equated with proof even so much as by a preponderance of the evidence. So when we're looking at this, in this particular case, we have much more than just mere speculation or suspicion or possibility. We have, based on the circumstances, based on what's laid out in the affidavit, based on the additional information that Sergeant LaCroix gave to the judge, we have more than enough probable cause to establish the issuance of this first search warrant with regards to the search of the defendant's home. The affidavit is not facially insufficient, and it's not overbroad. It's not just a broad sweeping, we want to come in and search for everything under the sun that could be related to any crime. It is specific to this crime, to this murder, to that location. He gives a description of the home. He gives a description of the items that he's specifically looking for. He didn't just put on there any and everything possibly connected to this case. He was very specific with what he was searching for. And unfortunately, they didn't find it. But they did take photographs. And at this point, Your Honor, I have no idea whether or not at any point those photographs will have any evidentiary value, whether they would be something that would come in as evidence with regards to somebody to contradict what somebody says. I don't know, but that's why I'm asking the court to uphold the search warrant. With regards to the second search warrant, the one for the defendant's DNA, on that case there is certainly probable cause for his DNA. By his own admission, he was there at the house, not just earlier at the party, but after the party, after the bonfire had ended. He went back there. He was with Jacob Koski. Now, of course, he limits his involvement in this, but we do know that he was there. He went in through the front door. He went in with Koski. He was present, at a minimum, present when this happened. There is evidence that he was a participant in this, a party to a crime of this, and certainly it would be, again, important to have his DNA with regards to this. Again, it would be something, it would just be fodder for the defense counsel at trial. They didn't even bother to get his DNA. They can't even say if he was there, if his DNA was present. So it's very important for them to get his DNA, and it is laid out in this search warrant why his DNA is being sought and why it is important. Because in this particular search warrant, he talks about Judge. He again lays out what is to be searched. It's the person of Matthew Baker. He gives a description of him, where he is located. So it is, again, not facially insufficient. He's talking about they want DNA evidence, saliva and or blood for the murder investigation. He goes through his qualifications. He goes through the probable cause, what was here going on in the case. He talks about in this search warrant that Mr. Baker admitted to meeting Mr. Koski at the back at the incident location, entering the house with Mr. Koski, watching the 4 victims being shot, searching the location for any other people, and leaving with Mr. Koski. It stands to reason that if he's putting himself there, that they would want to see if his DNA shows up there. So again, Your Honor, with all of that, both of these search warrants are sufficient. Neither one is overbroad. Neither one is lacking in probable cause, and certainly they are sufficient and they are particular as to what is being sought in the case. So we would ask that you deny the defendant's motion with regards to both of these search warrants and both of these searches.
All right. just so, I like to talk about things, but let me just point out that I'm pretty sure that if the affidavit says Mr. Hosky stated he directed cable through the back road to Highway 81 East, Highway 212, and threw one of the firearms out of the window, it doesn't say throw it out at 81 East or at Highway 212 or on any of the back roads, we don't know. And so, and I'm fairly familiar with Highway 81 East. In fact, this 3300 Highway 81 East, I believe I conducted the closing on it on the first sale of that home, the split driveway. We had to get permission from Henry County to put two houses on one driveway. Actually, Agricultural was closing to both those houses. I know very well where it is. I know where 212 is, because you can't get there from here now. The bridge is out, they're replacing it on Highway 81. And there's a lot of roads out there, a lot of back roads, some paved, some not. Where in the heck that gun may have gone out there, who knows? But, two, this is the trivia, there are 63 Jackson versus the state. 63 defendants named Jackson versus the state mentioned in the Georgia Criminal Trial Practice Handbook of 2020-2021. So if you're thinking of having a child, or someone asks you about naming your child Jackson, say, I don't think that's a good idea. Then a lot of Jacksons get into prison. Now, I want to also point this out, that we have to keep in mind that the defendant in any case cannot be forced to testify. And without being able to put the defendant on the stand, you're not able to question him about where he was, what he did, all those things. You have statements. And if somebody says they're in it, then the argument in closing is, well, we only have the statement, but the officer said that Mr. Baker was in the house. Why didn't they take his DNA? Well, you took his DNA, didn't pan out, you at least tried. So I think that's a lot to be said for this. But both the motions as to the DNA and as to the nothing that was found in the house from the other search warrant, both search warrants are sufficient for the minimum standard that is required under Georgia law to obtain a search warrant. It was not vague in any way, it was specific. Maybe not the entire book. Some of the books I read, whodunits, they always leave out a couple of clues that would help me if I figure it out myself. But they always leave them out. So there may be a couple of clues left out, but there's sufficient clues to figure out what they're looking for and anything specifically. So both motions will be denied. Now, as far as scheduling the remainder, I think it's a little early for us to do that at this juncture. I think the finishing the motion to suppress Jackson Deno's statement is going to be needed to be scheduled, but not until such time as everybody's had a chance to digest what you've been given. And today will not be sufficient. Maybe next week or at the latter part of next week, you might be able to come up with some ideas of how long or how much more you have to do. So we'll conduct the scheduling of that by email. I'll put it on my calendar, not to forget to. I think they call it, tickle it on my calendar. I won't make it pop up. I don't like to make it pop up too early in the day, because then I forget to do it. I'll make it pop up about 10 o'clock. Now, at the conclusion, we're not actually at the conclusion of two of the motion hearing, but the court should give the defendant an opportunity to state any objection to the defense counsel or the manner in which the defense counsel has conducted or conducting his defense. Any objection, Mr. Baker?
On the advice of counsel, I decline to answer.
Thank you. That's quite well on that question. Been consistent. All right, I will, we still have a scheduling order out there. I'll give you a copy of that, just keep one. But we are moving toward the finish line, at least motions. And whether I will then conduct the proper review and see whether something needs to go up. But what I will do, I have a pretty good idea of where the motion suppression statements is going now. I can at least get some research done. May prompt more research after the other question. The rest of the cross-examination, that detective and any other people we might end up identifying that didn't know were involved as a result of the body cam. And so we will be adjourned for the day. Thank y'all.
Thank you, Judge.
Like naming your child, Jesse. Probably not a good idea. Especially if it's fall.
That was always one of my favorite names too.
I don't know, my brother's the first son that was just like that family name, that's how I got one. Our uncle was Arch Kimber.
Oh, so it's not short for Archibald? Oh, it's just Art.
Just Arch.
Okay.
And all the luck in the world, I have a friend who's named Arch.
Oh.
And he's a couple years older than me, but friends of my brother and mine too. So sometimes, and we don't want to go away, he's a little older. He's got more of a turkey neck than I've developed, he got one. And he was a principal. And, I was,
Yes, if you wanna, we can all meet up, and pack up my stuff, we'll meet up. Okay, thank you.
You know, like this, a lot of things, like a big, she thinks I work for. I had to call her, but I tell her, you might have a parent call her. Yeah. I tell everybody, my mother was a
That's easy enough.
Breathe, start
But
to
I just
learn it
always
out.
thought it was short for Archibald because, yeah, I never heard it. Just never heard it by itself. There you go. That's what all the good people are doing. Okay.
Hopefully by the end of this week, I will get this.
Okay, Paul says he shows 4 transcripts, that's not counting the ex parte, and he's sending them now, and that was about 10 minutes ago.
Okay.
Just emailed them to her. I had him email them directly to you.
All right, thank you very much, I appreciate it.
No problem.
That's everything, I'm gonna put the other stuff back in later when we get back into the office.
Take care, Dylan.
Thank you. Y'all be careful.
Yes, sir.
Bye. See ya.
Thank you.
Still had ruined by,
Oh, really?
You don't wanna mess with
well,
this.
they got their closing arguments on Friday, the same day that we left town for 10 days. So by the time I got back, I had to take it right out of here after Labor Day.
Yeah.
All right, see you on the phone.
I didn't get, I told you, yeah, I'm gonna pick up this weekend, just
We can get you one if
quiet, and
you
basically,
don't wanna do
get
it.
my stuff out.
You only got 3 jobs,
Change
okay?
what they were wanting to do,
Thank you,
and
sir.
then comment on what they were leaving.
Oh, is the little bit
They had presented to them, probably could have worked out the settlement.
Yeah.
Yeah, I didn't work out it anyway, just the way I was.
There you go.
Safe journeys.
Same to you.
Yeah, I see that.
No, not yet. He's gonna send us emails and we'll go back and forth about scheduling that way.
that'll either come from Paul or Janice Baker and Associates.
Okay, thank you.
Okay.
Shannon takes the personal challenge to get 30 bags of public. I'm making one trip.
Y'all take care. Take it easy. What is your name?
Robin,
Huh?
Robin.
Robin and
Sawyer.
George.
George, nice to meet you.
Nice to meet you too.
My maiden name is George.
You should remember me then.
Yeah. I can probably remember that.
If we had got married and I had taken your name, that would have been really cool.
George.
I could have been George George. Now, is this thing still?
Still running? I don't know.
It's
I think
red.
they can shut it off.
It's red, I'm guessing not?
Well, it's been red all along.
Oh, has it?
Yeah.
Okay.
So I don't know why that is, but when they had their conference in here, when they didn't want anybody to listen,
Mm-hmm.
they took a mask and
Oh,
put
is
it
that
over
what
that.
they did? Okay.
And shortly after that, I was down in the hallway just waiting, and Mr. Baker's, I think it was his mother, that came running up the stairs.
Yeah, I'm not sure.
And she had just gotten here and wanted to know, somebody called her, and she wanted to know what happened at the feed.
Oh, okay.
So I told her what they were doing, but anyway, so evidently putting a mask over it does stop.
I guess so.
No,
May not stop the virus. but what's the difference?
yeah, exactly. In fact, really,
I know.
wearing a mask bothers me a lot because we're touching things, or it's just,
I swam in the creek and ate vegetables right out of the garden, so
yeah.
I'm not too worried.
Shoot, I didn't have this up right, I'm sorry.
You
I
what?
know you're waiting on me here.
Oh, no, we're fine, no. I'm here for a while.
I was just saying I didn't pack it up right.
Where'd you grow up at?